Well, good afternoon or good morning on the West Coast. Want to say hello and thank you for joining us. I'm Frank Lamonti. I'm one of the co-chairs of the Free Speech and Free Press Committee of the ABA's Civil Rights and Social Justice section. And in just a moment, I'll introduce you to the illustrious group of panelists that we have gathered today to address the subject of the Trump First Amendment Casebook. This panel is sponsored by the ABA section of Civil Rights and Social Justice. We're actively planning additional programs on a variety of issues, so please visit americanbar.org/CRSJ, Civil Rights and Social Justice, for updates on these programs. During today's program, we encourage you to ask questions of our panelists through the Q&A feature, not the chat, if you can avoid that, please. If you don't see the controls, please make sure your screen's not idle. I will watch that Q&A. We'll do our best to address the questions, time permitting. I always benefit a lot from the interchange with our knowledgeable audience, and we will be sharing a recording of this program with everyone who's registered, so you can share it widely with your networks that will live on the YouTube channel of the ABA section. So. Just briefly to give a hello to our wonderful lineup of speakers today. Ben Wisner is the director of the ACLU's Speech, Privacy, and Technology Project. Catherine Ross is the Lyle T. Alverson Professor Emeritus of Law at George Washington Law School. Josh Blackman is the Associate Professor of Law at the South Texas College of Law in Houston. And Danya Perry is founding partner of Perry Law in New York. So thank you again for joining us. Let me just do a tiny bit of setup here. Nobody joined this to hear from me. And then turn it over to our panelists, starting, I think, with Ben would make the most sense. Donald Trump is probably nobody's idea of a First Amendment icon if you're one of the journalists or news organizations that's been on the receiving end of his wrath. A number of times he's rattled the saber of using his authority over the DOJ or the FCC to go after news organizations that displeased him. But in reality, the former president has been an avid user, an avid beneficiary of the protections that the First Amendment has to offer, most pointedly in defending himself against various libel by tweet cases in which he has been able to successfully beat back claims by showing that he was hyperbolically criticizing fellow public figures. And so, in fact, the relationship between the former president and the First Amendment is a deep and abiding one that goes back quite a ways. But it is front and center today because of the various criminal prosecutions in which the president finds himself embroiled. And I'll just give a really quick overview of each one of these and then invite our panelists to jump in and address some of the issues. Leaving aside the hush money case in New York, Stormy Daniels is also a First Amendment beneficiary, but that's definitely a different conversation. There's the Mar-a-Lago classified documents case in the Southern District of Florida, brought by Special Counsel Jack Smith, that involves 40 counts against the former president, and that has been tentatively set for a May 2024 trial date. We don't know if that's written in stone or sand. There is Jack Smith's election conspiracy prosecution as well, pending in the District of Columbia Court before Judge Chutkan. That's 4 counts against the former president, trial date not yet firmly established. And then there's the case brought by District Attorney Willis in Fulton County, Georgia, the election conspiracy and RICO case that involves 11 criminal counts against the former president. And again, trial date TBD there. And each one of these cases, to varying degrees, implicates the possibility of a First Amendment free speech-based defense. So we wanted to ask our experts to address some of the First Amendment issues that have arisen in the course of these cases. I am just going to very briefly share a video that illustrates one of the First Amendment issues that I then want to invite Ben and Catherine to start us off by addressing. There we go.
We're not seeing it.
Yeah, I'm so sorry. It's taking me a second to get this to come up. There we go. So with his typical subtlety and understatement, the former president has let us know what he thinks about Special Counsel Jack Smith. Are you able to see the YouTube video now?
No.
Yeah.
We see a medium.
You know what? We're going to do without that, and we'll just
Do
talk
a really
instead.
good Trump impression and just like impersonate him.
There you go.
Frank, why don't you just summarize it? Because
I
nobody
will.
wants to lead in.
I will. So the both in the civil case that has just concluded with a $350 million plus award, and in the ongoing District of DC case, the former president has been subject to gag orders that restrict his ability, in particular, to criticize court personnel, judges, and prosecutors. In December, the DC Circuit weighed in and actually somewhat narrowed the trial court's gag order in that particular case. So now I'd like to invite Ben, why don't you start us off, and then Catherine jump in on, I think a good way to frame this might be to look at, well, what does the law generally tell us about the ability of judges to gag trial participants? And then does the rule change? Should it change in the case where the trial participant is not a normal trial participant, but is the most prominent elected official slash political candidate in America?
Well, I want to first comment on your introduction. It's true that Trump is an unlikely poster child for any First Amendment issue. I remember when he was running for president the first time in 2016, and he insisted that he was going to rewrite the libel laws to make it easier for him to sue the media. Of course, not only is there no federal libel law to rewrite, there's a First Amendment obstacle, and it would probably cost him more than anyone if the libel laws were written to make life easier for plaintiffs rather than defendants. But I think when you're dealing with Trump, and maybe I'll start with the second part of your question and work back to the first. We're not only dealing with his First Amendment right to speak. We're dealing with the very important public right to hear. Like it or not, Trump is a crucial public figure. He is a presidential candidate, likely to be his party's nominee. The fact that he's also a criminal defendant means that there are equities that have to be balanced. And I sympathize with Judge Chutkan and others who have to deal with very real safety issues, particularly on behalf of the private citizens who are being dragged into these cases. I feel a little differently about the public figures like the special counsel himself. And the fact that Trump is running for president and the trial is an important part of that. And so start with what we believe, the ACLU believed was the overbroad gag order in the DC case brought by Jack Smith. Judge Chutkan said that Trump could not target the substance of any potential witness's testimony. What does target mean? First of all, it was not about threatening witnesses. Target could be innocuous and it could be quite violent. It simply wasn't precise enough given the high stakes of Trump as a presidential candidate. What about the substance of any witness's testimony? Witnesses are going to be testifying about what happened on January 6th. That's a very important issue in the presidential campaign. I would suspect that President Biden will make it a central issue in that campaign. And what does it mean to say that Trump cannot target the substance of testimony related to that? And so our point was not that there couldn't be a narrowly drawn gag order on Trump with the goal of ensuring that witnesses were not intimidated or threatened, and non-public figure court personnel were not threatened or dragged in or doxxed in such a way, but rather that the courts have to be extremely careful. And does that mean that Donald Trump is getting the benefit of the doubt here? It actually does. And I think some people are very offended by the idea that he might get a more lenient standard here than an ordinary criminal defendant. Well, again, this is where we have to weigh the public's right and need to hear what he has to say as someone who is a leading party presidential candidate. And so, again, I don't envy the judiciary having to deal with this. I think the DC Circuit got it right when it narrowed the gag order that had been imposed by Judge Chutkan. And maybe Catherine has more to say about the general legal standard that applies in these cases.
Yeah, so first of all, I hate to be not on all fours with the ACLU's counsel. So it's an uncomfortable position. And I also want to say something about First Amendment plaintiffs generally. The annals of the First Amendment are full of really unpleasant characters saying really noxious things. That's what we have the First Amendment for. And so in that sense, Trump is a representative First Amendment claimant. He also used libel law enormously before he was president by suing all kinds of media outlets, from the very powerful on really ridiculous libel claims, like going after somebody writing what is clearly an opinion column, but also the kind of small publishers and speakers who don't have deep enough pockets. And he used the threats of suit to silence people who were critical of him or threatening to expose some of his fraudulent and other unpleasant practices. So his relationship with the First Amendment goes way back before these trials and before his efforts to weaponize it while he was president. In terms of the gag orders, I actually think that Judge Chutkan got it right, even though it might have been, tweaked, more narrowly crafted. I think the DC Circuit's opinion was fine, but she was talking about the way in which his out-of-court statements undermined the administration of justice, threatened the existence of a jury pool that would not be contaminated, attacking the witnesses' statements out of court for someone who has such a big platform is really different from if even one of us who are, prominent enough to appear on a webinar, which is great prominence, if we went around attacking our witnesses against us, it wouldn't be in the mainstream media. It wouldn't be all over Fox News. And so, Trump has a background and we know he's trying to try all these things outside the courtroom. So how do we control that? And here, I think there's a real difference between a criminal trial and a civil trial. Even in the civil trials, like the civil lawsuit brought by the state of New York, in which he was essentially fined $350 million, accumulating interest at the rate of almost $1 million a week. There were some gag orders needed because of his threats to the judge's clerk and other personnel. The judge was also threatened, as I understand it. At one point, he had to move out of his home. But he didn't include himself in the gag order. He was very meticulous. So one question is, did these statements by Trump rise to the level of what in the First Amendment we call a true threat? They may or may not have, because a true threat is a really hard thing to prove. But we also had a lot of evidence about what the listeners do who favor Trump in response to some of these provocative statements. So even the civil courts can put in place gag orders that will be upheld. In this criminal context, it is even a stronger argument that defendants can be gagged because Trump is out on his own recognizance in these cases, in the DC case, for example, and in the Atlanta case. And he got special treatment by not being confined prior to the trials. He could have been. So if he were incarcerated while waiting for trial, he would be subject to all the rules that people being held in a prison are subject to. including limited phone calls, limited contact with outsiders, rules about what he can read, and screening of his letters when they leave the jail. So I think he's having a great privilege already, and the conditions of his release can be specified, and they can include a gag order, and he can have his freedom revoked if he violates the gag order. I'm a big First Amendment person. And I keep asking myself, am I saying this because Trump is special to me as he is to many Americans? But I don't think so. Those are the rules that apply to criminal defendants. And I think that implies my answer to the second part of the question. No, he doesn't get special treatment. Voters do have a right to hear, but they're going to hear from him wherever he is about many, many things, just not about things like undermining the administration of justice in his own trials.
So that was styled as a disagreement with me, but actually I didn't hear any disagreement
good.
because we agree that gag orders can be permissible to protect the safety of witnesses. We agreed that the district court's gag order was overbroad, and we agreed that the Court of Appeals narrowed it in a way that was appropriate. So I don't actually disagree with any of those things. I would say we should not deem pretrial confinement as the norm and being out on bail as the exception. There is no plausible argument for Trump to be confined pretrial in this case. These are not violent offenses. No one thinks that his being free, I don't know, but Danya, you probably wouldn't even argue for him to be denied bail, right? When you were a prosecutor, right? So,
Even
yeah,
now,
yeah.
can
Go
I
ahead.
can I add 2 cents? And truly, it's
Please.
only 2 cents, because I'm not a constitutional scholar like the other giants on this panel. My perspective is as a former federal and state prosecutor, and now as a defense attorney who is defending Michael Cohen. I represented him in the Attorney General's civil suit. I'm representing him in the upcoming criminal trial at the DA's with the DA in Manhattan. And so my perspective here really is very narrowly focused on the threats to him as a witness in those trials, which are very real. And so I do take a little exception to the ACLU's take in the amicus brief that was filed in the case before Judge Chutkan. As a general matter, of course, direct threats, I think we all agree, those, there can be a prior restraint on those when they're directed at witnesses in an upcoming trial. Here, as with most things Trump, there are many things sui generis, and here he has a very unique relationship, of course, with his supporters, and there certainly, and I've seen this up close, and I think there's certainly a phenomenon where a mere word or tweet or truth from him can set off a chain reaction, and certainly, and as we get closer to trials, there has been a chain reaction where he will say something and we will see an uptick in reaction from his supporters. And so I do worry, and we will see. Judge Engoron, we saw that in the OAG trial in New York. He did issue narrowly focused gag orders. We'll see. Judge Merchan has been quite restrained. We'll see what happens. But I certainly would support, of course, as Mr. Cohen's defense lawyer, if we do see any activity from Mr. Trump, certainly I think we could all agree that at least as a narrowly tailored approach would be appropriate, even though the direct threats would not come from Mr. Trump himself, but in reaction to statements he might issue.
So actually, there are two questions in the Q&A that touch on exactly the point, Danya, that you and others have been making, which is to what extent do we hold that speaker responsible for foreseeing the way that others are going to act out or might act out following their instructions? And of course, we're about to have a very rich discussion of the law of incitement when it comes to the January 6th case that Jack Smith has brought. But previewing that, right? And anybody who'd like to address this, does the fact that the former president has this very large megaphone with this very large and devoted following, does that weigh in a First Amendment gag order analysis, or should it weigh? Do we have, I think Ben set out an interesting argument that maybe there is a thumb on the scale for prominent political candidates because of the need for them to be heard. I think Professor Ross set out the thumb on the scale the other way, that perhaps people with large and rabid and motivated followings get an extra thumb on the scale of restraint. Anybody want to break the tie?
I'll say one thing and then I'll turn it over to Josh because he hasn't had a chance to speak yet. When I was speaking to people in the public policy departments of the major social media companies that were kind of trying to make this decision and with different stakes, should he be allowed on the platform or not? Should he be subject to the same standards as ordinary users of Facebook, or should he be subject to a different standard? I think I answered the question in both ways. I said, when you're talking about political speech on a matter of public concern, you need to err on the side of letting him speak, even if some of his political speech might violate terms of service as applied to another user. If he's using his platform to target an individual private citizen, then you need to be stricter on him than you would be on another user, precisely for the reasons that Catherine raised and Donnie suggested, which is that there is actually more danger if he's targeting millions or tens of millions of supporters, or suggesting that they target a private citizen. So I think those are consistent, right? There's no reason why my point about the public's right to hear in an election year needs to bear on whether a judge prevents Trump from intimidating a witness. Danya's concern here. I think we're all on the same page about that. And I don't think the standard for a gag is exactly the same or as high as it would be for a threat or incitement. It can be lower as long as there is a real finding, based on real world factors. So I think the answer is both things are true. That when you're dealing with a gag that might touch on Trump's ability to talk about issues that are core election issues, the court has to be extremely careful and tread carefully. And if you're talking about Trump's use of his megaphone to urge his following to go after private citizens and witnesses, then the court, I think, can use even more scrutiny than it would for an ordinary defendant.
I'll chirp in a bit. So I was listening to conservative talk radio today, which maybe no one else in this call has ever done recently, at least. But one of the points they were making was Trump's comment about Navalny, about how, I'm like Navalny, saying, "Oh, how dare you compare it?" And the argument the host raised was actually somewhat unexpected, that the entire consortium of civil and criminal litigations against Trump in the last year has been designed to take him off the ballot and make him a viable political candidate. In other words, that everything from the Letitia James case, to the hush money case, to the Fani Willis indictment, to the Jack Smith case, even the timing of waiting till the last minute, that all this is designed to basically shut him up, get him off the trail, and to make it harder for him to do his job. So I think the disagreement we have between Ben and Catherine is actually well stated. But one perspective is everything you do to Trump in particular in this sort of unique moment is basically done with an eye towards weakening Trump, and whether that's the intent or the effect, that's how it's perceived by huge swaths of the population.
Whatever you do with the volume, Josh, worked beautifully, because we now at the very end can hear you much better. So thank you.
Right. I'm sorry I couldn't hear the first part.
Yeah. Well, I want to invite anybody who wants to weigh in on the gag orders to weigh in, or if not, I want to turn the page and talk about the incitement issue that has been raised by both this discussion and a number of our questioners in the Q&A.
This is perhaps a segue between the two topics, but I wanted to remind people about the E. Jean Carroll second trial and what Judge Kaplan told the jurors when he dismissed them, because it was blood chilling. And Judge Kaplan is not a guy who's, shooting from the hip. He's a thoughtful, careful, and very analytical person. And he told the jurors that they must never, ever in their lifetimes tell anyone that they were on this jury, because it would risk their lives. So that is how powerful Trump's messages to his supporters are. That is how violent some of his supporters are. And I think that really needs to be out there in the background of our conversation. And former federal prosecutors who've done mob cases said, even in the mob cases, judges almost never say this.
There is a question in the Q&A that I will modify slightly, but try to get the gist of it, which is, does it matter? Should it matter? Does it matter in a First Amendment analysis that that there is a suspicion that the former president / defendant is attempting to influence future jurors? Is that a factor that is legitimate to consider as a judge is weighing whether to impose a gag and with what breadth?
Context is always really, really important in First Amendment cases. And in First Amendment cases, we often talk about what we call constitutional facts. They're more like, they're more than, who was driving the green car when it ran the red light, because that doesn't affect our analysis of whether they were speeding. But we have to understand the context in which words are used.
Can I just add, though, I think at this point, the jury pool is as tainted as it's going to be. I mean, there's no one in America who's not well familiar with the facts of the case or who Trump is. So I think that is uniquely, again, in this case, probably not as much of an issue as it normally is when a judge is concerned about tainting a jury pool. That's just an opinion, though.
Danya, I may ask you to address this one in the Q&A, since you have an active litigation practice and have been on both sides of that V in federal court. As a practical matter, how would a gag order actually be enforced under these circumstances? Even with the gag order in place, how is that enforced in reality? Who has the responsibility for that? It does raise the interesting spectacle of what contempt sanctions would look like against, again, a former president who is actively on the campaign trail. How would it be enforced?
Well, I'll say, despite having, practiced both as a prosecutor and a defense lawyer, I've actually never been a lawyer on either side where a gag order has been imposed. So I don't, again, it's so rare for good reason. But having studied it as a result of these cases, I think, of course, Judge Chutkan or any other judge would be very, very loath, as Catherine said, or Ben said, to actually impose, certainly, to revoke bail in this case. That would be unthinkable. So just as Judge Engoron did, the first case scenario would be to impose monetary sanctions, a fine. Judge Engoron, it was, I think, $5,000 and then $10,000, a very low amount that is truly non-punitive and merely, symbolic, right? And he made a finding of an adverse credibility finding. He put Trump on the stand and said that he did not find him credible when Trump said that, no, in fact, when he made statements that he wasn't talking about the judge's law clerk, that he was talking about Michael Cohen, and the judge didn't believe him. So, the judge does have tools in her or his toolkit, depending which judge it is, and can impose sanctions, can impose, a tighter gag order, can impose a fine, can impose a house arrest. I mean, there are increasingly more rigorous terms of a bail, can take away his passport. I mean, that sounds ridiculous. And then I get, the most obviously, up to and including revocation or remand. But obviously in these circumstances that truly seems unthinkable, but it does seem, that Mr. Trump could almost thumb his nose and go so far as to tempt her. I mean, during the short period where the gag order had been stayed after Judge Chutkan had imposed it, he went out and made comments about Mark Meadows in that short period where it appeared that Mr. Meadows was cooperating. He went out and made comments about him, and it seemed that he was almost, tempting her, baiting her. So, it won't surprise me if as the trial gets closer. And again, I have that concern, as I said, about the Danny trial, the DA's office trial in New York, that Mr. Cohen is going to be under protection. And I think with good reason. So we'll see, but I think a judge is going to be very, very reluctant to impose the ultimate sanction here.
Well, having been burned with the technology once, I hesitate to try this, but I'm going to go back to the well and try again to share with you a video. Are we seeing it now?
Yes.
That illustrates the next topic that we want to talk about.
One of our great achievements will be election security, because nobody until I came along had any idea how corrupt our elections were. And again, most people would stand there at 9 o'clock in the evening and say, I want to thank you very much. And they go off to some other life. But I said, something's wrong here. Something's really wrong. Can't have happened. And we fight. We fight like hell. And if you don't fight like hell, you're not going to have a country anymore. Our exciting adventures and boldest endeavors have not yet begun. My fellow Americans, for our movement, for our children, and for our beloved country. And I say this, despite all that's happened, the best is yet to come.
Okay, so we all recognize what that is and where it's from January the 6th outside the White House. And we all know what happened subsequently. So Josh, why don't you start us off? Is there a First Amendment defense to be mounted in this case? And what does that look like if the president is facing, so by the way, that speech was implicated, right, in two contexts. It's been implicated in the Colorado ballot challenge as to whether the former president under the 14th Amendment can be disqualified from even appearing on the ballot. It's also implicated in the Jack Smith case, although there's not an incitement to violence charge there, but it certainly implicates the encouragement that he gave to people who then ransacked the Capitol. So the question, Josh, is there a First Amendment argument to be made that that's protected political speech and not incitement?
I think I was one of the first people on planet Earth to say yes. I was actually on cable news on January 6th that evening. And as and as things were still being recovered, it was around 6 or 7 p.m., people were still sort of being removed from the Capitol. I went on cable news. I said, Brandenburg, I said that on the air. People were shaking their heads. I think I was the first, maybe not the first, but probably one of the first. And I said that this was not a speech that it incited imminent violence. And, I did the best I could on a cable news show. You only get a few moments to make your points, but I made the argument. And I realized immediately that there was actually going to be a trial very quickly, which was impeachment. So in addition to the two you mentioned, you have Jack Smith, you have Colorado, you have we forget there was a second impeachment, right? You have the second impeachment trial, which was based on incitement of insurrection. And I actually put out, with my colleague Seth Tillman, a post published January 8th at 3:57 a.m. We spent basically all day the 7th writing it, explaining why this was protected by the First Amendment. And we laid out the case. This was not imminent. There was distance from the White House to the Capitol. His speech had some remarks saying, go be fight like hell, but also march peacefully. Maybe shaking your head, I can see. People said we're wrong later. It's the beauty of Zoom, as you can see reactions. But we made this argument. The initial response was not that we were wrong in the First Amendment, but the First Amendment had no bearing on impeachment, which I think that's actually wrong. If you look at the Johnson impeachment, there were First Amendment defenses raised there as well. But putting aside whether the impeachment saga, because it yielded an acquittal, was Trump's speech protected, I was surprised how quickly law professors came out against this, and including people like Floyd Abrams, who I have the world of veneration for, saying that Trump's speech did not fall within the Brandenburg protection. Catherine can nod yes to that one. And a lot of law professors said that this was not protected for various reasons. Here's the way I look at the Brandenburg question, right? And this is an issue that Brandenburg itself didn't resolve. when you're considering the Brandenburg test, do you look at the speech itself or the conduct leading up to the speech or what happens after? And I think that's actually an important question. If you look at nothing but the four corners of Trump's speech, or at least the digital version on YouTube that was shown a moment ago, I think the incitement to violence claim becomes harder. But if you couple it with his tweets like, it's going to be wild and all the election interference stuff leading up to it, the case becomes easier. If you look at what actually happened, it becomes much easier. The Supreme Court of Colorado addressed this briefly, and it wasn't persuasive. They said, well, under the Claiborne hardware store case, you're allowed to look at context. And they brought in some cases involving true threats like Counterman, which said, yes, you can look at context and decide something's a true threat. I agree for true threats, you need to look at context, but in my view, the sort of sine qua non of Brandenburg is imminent. What's happening right there on the spot? And I don't know that there's a clear Supreme Court case saying either way you looked at this up before. So if you just look at the four corners of Trump's speech, not going to the weeks beforehand, I think that's politically protected speech. And even if it's not, if it's a close enough call, it should not be the basis of a criminal indictment, which is why Jack Smith has not indicted him for it. But this matters for insurrection because if it's protected speech, you can't, I don't think, use it against him. Now, Will Bode and Mike Paulson said that Section 3 implicitly repeals the First Amendment. I can have an entire podcast on that one. I won't bother with it. But just focusing on the First Amendment issue, I think to get Trump on speech, you need to loop in stuff that happened before, if at all. And I don't know that you can do that under Brandenburg, but people will tell me why I'm wrong about that.
Catherine, do you want to just lay us a foundation about Brandenburg? This is the 1969 Supreme Court Brandenburg v. Ohio case, and just sort of lay us a foundation about what happened there, the test that's been set out, and how that might play out in a scenario like this one.
Okay, so Brandenburg involved the civil rights movement and events leading up to and connected to some acts that were lawful and some acts that were not lawful. And at that, before Brandenburg, people were prosecuted for a rather broad range of statements that could be understood to lead to violence. But the Supreme Court there said, if we're talking about criminal incitement, and this was in 1969, that you could talk about and advocate the use of force and the use of illegal acts like a boycott that was not legal for various reasons under state and local law, except where the advocacy was directed to inciting or producing imminent lawless action and is likely to incite or produce such action. So imminence is really important. And one thing that was cut out of the clip that Frank shared with us, which was a great clip, was when Trump said, so I want you to go, I'm paraphrasing, I want you to march right now down Pennsylvania Avenue to the Capitol, right now, and I'm going to go with you. That is imminence. And Brandenburg makes clear because it analyzes the events leading up to the speech for which Brandenburg was charged as inciting, and the events that followed. And there was a time gap in Brandenburg between the speech and the events that followed. So he could not be held accountable for them. But with Trump, there was no time lag. They went directly, and that's exactly the hypo that we law professors use in class. The hypo is always, let's go right now and burn a cross on the civil rights leader's house in his yard. But if you say, let's go to Washington next month and do violent things in protest, that doesn't meet the imminence test. So this was a classic imminence. And you can look at the events leading up, including It'll Be Wild, and the months of trying to undermine faith in the legitimacy of the November election that started even before the voting took place and continued right through January 6th and to this very day. And what followed was not just that this was likely to produce, But in retrospect, we know it did produce, and now we have these hundreds of January 6th defendants saying, I broke the law because he told me to. So I think it's a pretty strong case. On the other hand, it is much harder to establish incitement in a criminal trial than it would have been in a serious Senate trial, because a lot of the rules of evidence and a lot of the standards are different, and there's no judge in charge at the Senate to instruct the jury on what the standards are, nor did the Senate ever discuss whether it was going to apply Brandenburg or trust its gut, because it wasn't serious, and the Republicans never intended to listen and consider convicting.
So, Danya, would you care to put your prosecutor hat or your defense attorney hat on and make a case one way or the other for how this one should come out?
Yeah, I'll put my prosecutor hat on here because I along with some co-authors, we wrote a Brookings Institution piece about this during the January 6th committee hearings, and I predicted what the criminal statutes under which the special counsel would indict, predicted them properly, because as you point out, Frank, the statutes under which special counsel Smith indicted was not, this is not an incitement case, right? It's intent to defraud the United States, it's obstruction of official proceedings and on. And here, sorry, there's some noise coming in. And here, the intent to defraud prong, it criminalizes conspiracies against the United States. And it's not, as Trump has argued in his motion to dismiss unsuccessful,y this is not a speech crime. This is, as with all things, Trump, there's, this rhetoric that's Orwellian and dystopian, and, they're criminalizing speech that they don't like and all of that. But really, 18 United States Code Section 371 is certainly the most often, indicted statute in the code book. It's bread and butter every single day in the United States. I don't know how many, but defendants are indicted under the statute, and usually, yes, their speech indicted. One or more, at least two co-conspirators get together and they plot something, their scheme. They get together and they, come up with a ruse or, a scheme. It involves fraud, deceit, dishonesty. Here it's to upset the lawful functions of the United States. But it involves, and it's making, knowingly doing so, right? So here, the government's going to have to prove that Trump knew that what he was doing was wrong, and that the dishonest means or the statements he was making was false. So we can put that to the side because that's going to be an uphill battle. But also that there was an overt act. So it's not just a speech crime. There were acts taken in furtherance of this conspiracy. And here there's plenty of overt acts that are alleged in the conspiracy. There's a false slate of electors. There are plenty of overt acts that were done to pressure the vice president, that were, phone calls made to election officials. I mean, there's plenty. So I mean, whether, I would not want to be a defense lawyer in this case, which is why it's easy for me to put on my prosecutor's hat, because I think that this is going to be a tough one to defend when there's so much here that I think goes to show, at least on the face, of this indictment, that there was a lot more than just speech here. And I think it was clever to frame this, as not incitement, but as a conspiracy and as obstruction of official proceedings, which hundreds of defendants have been charged with and convicted of. And so I think the Alvarez case that Trump in his papers cites over and over again, where the Supreme Court said you can't criminalize false statements, essentially. And that's, for the benefit of those, who haven't read it, that's where, it had been the case that on the code books, it was a criminal act to pretend that you had won an award for military honors. And here, a gentleman had claimed that he had won the Congressional Medal of Honor falsely. And that was 100% clear. And he had been prosecuted and convicted of it. And he had pled, actually, but had carved out his right to claim a First Amendment violation. And the Supreme Court agreed by a plurality, and there were a variety of opinions, but they all agreed that you can't prosecute just the fact of just because it was a false statement. And here that's not that the Judge Chutkan found that this was not just, he's not being prosecuted for simply making a statement that the government believes was false, that it was more than that, that it was, there were actions, taken in furtherance of the falsity of the statements, but also the government's going to have to prove that he knew and believed the falsity of his statements. Sorry, that was a bit overlooked.
No, that's great. And I want to run through we have engaged in some incitement ourselves here because we lit a fire under the commenters. There is a lot going on in the Q&A. Let me start with, I'm just going to read this one verbatim. The events that took place on January 6th were widely publicized to the public. Everyone knew that it was going to be a riot and at least violent. Do you think that this lack of acknowledgement has and is affecting the case? I'm not super sure what's being asked there, but does it matter, I guess, that the event was already well publicized to the public and that there was already reason to suspect that people might engage in violence?
So the Colorado...
You want to go ahead, Josh, and then I will?
No, you can go. You go first.
Okay. I mean, I think it's very hard to evaluate this in hindsight, knowing now exactly what happened. But there's a reason why Jack Smith didn't charge incitement, and there's a reason why the Supreme Court has set the bar as high as it did for the crime of incitement. And that's because, remember, what we're talking about here is when are we going to hold somebody, in this case, criminally responsible for the actions of someone else based only on his words. And I would add, in addition to imminence here, really an intent, because we want to preserve this for when someone actually intended the criminal and violent conduct that followed. Going back to January 6th, it was pretty clear that Trump intended for something raucous to occur. But remember that if there had been 200 more police officers at the Capitol, we'd be talking about a very different day. We wouldn't be talking about selfies on Nancy Pelosi's desk. And so I think now we associate the speech with what happened, and how could we not? It is exactly what happened. It's at least consistent with what he said on that day. But I think the special prosecutor was right not to make an independent charge out of that. And I think, as Danya pointed out pretty well, there's a case against Trump that doesn't implicate the First Amendment very much if you talk about his private conversations that he had, going to the Attorney General and saying, just announce that there's fraud and Congress will take care of it, trying to put together false slates of electors in states, trying to pressure state secretaries of state in private phone calls to come up with the votes. These are things that no one's going to argue are protected by the First Amendment. Whereas I think when you talk about a political leader's public speech to a crowd, on the one hand, you have the paradigm of the incitement. You have a charismatic demagogue and you have a very riled up crowd, but we're still not talking about an eggshell skull rule like you are in torts, where if you intend for one bad thing, all the other bad things that happened are going to be laid at your feet. The First Amendment doesn't allow that when we're talking about liability for speech. There has to be more of a straight line between what you intended with your words and what followed. And I think this would have been a hard case. And I also want to say, reasonable minds can differ here. Judge Amit Mehta in the district court in DC wrote a very good persuasive opinion in one of these cases in which he concluded that it was incitement. I have a lot of respect for Amit Mehta. I thought it was a very smart analysis. I probably fall slightly on the other side of that, but this is a very, very close call.
Josh, go ahead. What were you going to say?
I think it's important to sort of keep the chronology of January 6th in mind. the ellipse where you show the videos at 1.5 miles away from the Capitol. It's about a 30-minute walk, assuming you're at a brisk pace. If you're with thousands of people, probably take a little bit longer. So there was some of a period of gap between the speech. By the time Trump got to the microphone, people were already storming at the Capitol. So I think a lot of the initial sort of violence was actually even before Trump opened his mouth. So I do think the imminence issue actually is trickier. In fact, most of the people who were at the ellipse never even made it to the Capitol because there was so much chaos going on. By the time they walked 30 minutes, they were being locked down. So I think the thread between the speech itself and the incursion of the Capitol is actually harder to draw. What you really need to do is loop in this stuff beforehand to the point of, everyone knew there was going to be a riot. What happened in the Colorado trial court was they said that Trump was speaking in sort of coded language in his tweet and otherwise, where he might have said one thing but actually meant something else. And that gets to be very, I guess, very, I don't know if it's an objective standard or subjective standard, most mind reading. But as I understand the First Amendment doctrine, you don't go that far into depth for the incitement standard. You might in other contexts. I think it becomes extremely problematic when we're trying to say we're going to look at a speech, but understand all things that came before it and other things to understand, and then impute liability for that reason. Maybe to Ben's point before, even if it's a close case, right? We're not sure. I usually err on the side of letting the speech go forward. And I hate to do slippery slopes because it's not a very good argument, but I'll just raise it. If we start saying that Trump's speech was incitement, then there's a very long list of politicians who gave similarly rousing speeches, and things happen, maybe not right away, maybe within 30 minutes afterwards, that can be seen as interfering with government, that can be viewed as incitement of violence, and maybe incitement for insurrection. So this is why I wrote what I did on January 6th of 2021, that we should not be using the First Amendment, we should not be using the political speech as a basis to punish. There are lots of other ways to punish people who engaged in violence at the Capitol and putting their feet on Nancy Pelosi's desk. There are crimes for that. Trump was charged with other conduct that I think you might get conviction on, but you don't need to charge him with insurrection and incitement. Incitement, and he's not been so charged criminally.
There's a question that I think touches on what the both of you just touched on, which I'm just reading again. Given the events of January 6th, wouldn't a judge be permitted, if not required, to heavily weigh the propensity for violence and mayhem that could result? So in other words, does it matter and should it matter? And again, given that this is not an incitement case, but as a case, one of the primary charges is, as Danya explained, attempting to interfere with the government proceeding, right? i.e. the certification of votes. So does the defendant in this case get sort of charged with knowledge of the propensity of his audience?
Look, I think everyone has sort of said the same thing here. The context is a factor. And if everyone in that crowd had been carrying an AK-47, that would be a factor. If they were carrying banners saying, "We're here to take over Congress, and we're going to break down the walls," that would be a factor. So yeah, of course, you have to weigh the words against their intended and likely impact on the people who are listening to them. What I'm saying is that if the intent and likelihood was that they were going to surround Congress and scream so loudly that they disrupted the proceedings inside, but what actually happened was that the security wasn't sufficient to keep them out and they ended up on the desk. We don't say, when we're holding someone liable for his words, that anything that flows from that, as we would in some tort doctrines, can be laid at his feet. The First Amendment imposes some limitations there, right? We really want to say, if we're going to hold Trump responsible for those actions, those specific actions have to be the ones that were intended, called for, and likely to occur.
Yeah, I'll just add as a footnote to that, Frank, that I think cleverly, again, the indictment adds as one of the components to the defraud prong. I think one of the, 5 factors, the exploitation of the violence. So it kind of folds or bakes in to the fraud, the fact that Trump, as the violence was unfolding, that he exploited it and refused to quell it and use that to advantage. So I guess that kind of answers the question. I think that at some point he was aware of it, right? Certainly during while it was going on, and then refused to call it off or whatever. So at some point I think that kind of becomes part of the conspiracy.
We have the Supreme Court's decision, somebody raised in the chat, the Alonis decision, which was somewhat unsatisfying, inconclusive, and didn't really reach the First Amendment issue. But then in Counterman, the Supreme Court does come back and tell us a little bit more what they're thinking about the state of mind that's necessary to convict somebody. Again, not a case involving disruption of government proceedings, but do any of those doctrines come into play here? And I'll also add that several people have asked about threat speech as opposed to incitement speech. Do any of those doctrines come into play, or is threat speech not on the table here?
Well, I don't think
Go for
this
it.
was under true threat, which I mentioned when I was talking about the gag orders, because for true threat, you have to say, I am going to come after you in a way that either a reasonable person would understand to be threatening and scary, or in some states, just subjectively strikes you as threatening. But it can't be somebody should kill this person. So, and Trump is an expert at crafting his statements to be just on the other side of the black line and say, I never said that. So he's either, I'm joking, I heard it somewhere, somebody should. He's certainly never going to pick up the gun, except in his hypothetical about killing someone on Fifth Avenue. So I think that we're wise to avoid that in these Trump cases.
Yeah, I think I appreciate what Catherine said. Trump is perhaps a unique politician in that he's able to sort of, maybe not successfully, but toe that line so creatively and consistently. And that's why he gives, I think, so much difficulty to First Amendment doctrine throughout his presidency. There's a related point, though, that might be worth just sort of leaving in the background. People have the right sort of to vote for the candidate of their choice. And we can maybe pivot for a bit. The insurrection case involves the First Amendment issues, right? The right of people to associate with a candidate. And even if you think that Trump might be disqualified from holding office, there's an argument by the Colorado Republican Party that they have a First Amendment right to pick their candidate, even if their candidate can never even be on the ballot. Now, they don't agree with that. So there's even a First Amendment right to vote for potential insurrectionists. I don't think he is. So the First Amendment right kicks in almost at every facet of this discussion. It's truly, you can write a casebook about it. I think that's a good title for this podcast.
So Ben hinted at this, and I'm not putting you on the spot, Ben. This is not Socratic method, but anybody who wants to take this, there's a couple of variations of the same question here, which is there a case that anybody knows of that stands for this proposition that we charge the speaker with knowledge of the propensity of the audience, so that that goes to the speaker's mental state, such that somebody who's speaking to the AARP is different from somebody who's speaking to the KKK, right?
I'm offended by that No.
It was meant for contrast.
Yeah, I don't know. I remember the Supreme Court cases usually involve the latter scenario and usually find no incitement constitutionally. So we don't have a lot of jurisprudence where courts have found that something did meet the standard, but Josh has probably researched this more than the rest of us more recently.
There's another case involves, guess, Trump. So at a rally, I think it was either in Michigan or Ohio, it was a Sixth Circuit case from 2016, where he basically picked on someone that, hey, you guys get him out of there, right? You get him out of there. And they actually brought an incitement claim against Trump. And the trial court, I might be wrong on this, but the trial court actually said Trump knew his audience, and he knew when they say, get this guy out of here, that they will use, physical violence.
Even though Trump said, don't hurt him.
Yeah, yeah, exactly. That was it. You got it. That's exactly right. So
Yeah, but it was coded language because in a prior rally, Trump had said, "I'll pay your legal fees."
right.
Right. So that's what the trial court said. Like if you make a pastiche of all the things that Trump has said to his crowds, the fact that he said "don't hurt them" is not enough to overcome the other incitement factors,
But it
right,
was
Josh?
reversed on
Right.
appeal. It was an opinion by Judge McKeague, if memory serves. And McKeague said, no, you can't look at like, the subjective intentions and the past context. That's like limited to what was done on the spot. So it's sort of to the point before is how broad is the range of information you can consider with an incitement claim. At least that Trump Sixth Circuit case said you don't consider the entire gestalt. But I might be remembering it wrong. I haven't looked at the case in some time. And
I
someone
want
says,
to move us
sounds
to
like
the
Ohio to me. Might have been Ohio.
I want to move us real quickly to the third topic to keep the discussion moving, even though by the chat, clearly we could spend an entire hour and a half on the law of incitement speech. I'm glad people are interested in that. Is there, and I am going to put Ben on the spot here because one of his clients has been a guy by the name of Edward Snowden, whose name may be familiar to some of you. Is there a First Amendment argument that could be raised when and if we get to the case involving the Mar-a-Lago classified documents? The Supreme Court, there's kind of an asymmetry, you might say, in the law of the First Amendment as it regards the leaking of classified documents, right? The court has told us that you cannot enjoin a publisher from publishing newsworthy information, even if a leaker purloined them from his government workplace. But that is not to say that the First Amendment is going to protect the act of purloining them from the workplace. And so, Ben, I wonder, I mean, if you can address sort of more generally, does this context, and we may find this as maybe a non-academic discussion in a few weeks if Julian Assange is extradited to the United States. But is there a First Amendment argument for a quote unquote right to leak? And if that exists, would it come into play at all in the Mar-a-Lago documents case?
So just a little context here. We're talking, of course, about the Espionage Act of 1917, which is the principal federal criminal law that's been used against leakers. But to give some historical context, right, this law is enacted in 1917. The first time that it was ever used to prosecute something other than espionage, but to prosecute a leak of classified or defense information to the press was in the Pentagon Papers case, was Daniel Ellsberg in 1971. And of course, that case never was adjudicated because it was dismissed with prejudice for outrageous government conduct. The government had wiretapped Ellsberg's lawyers and weren't able to give a sufficient accounting of who had been wiretapped and who wasn't to show that there wasn't prejudice, and the judge just threw that case out. Now, Daniel Ellsberg, who passed away this year, liked to say that there was apparently a bench memo in that case, and that the judge was considering dismissing that prosecution on First Amendment grounds, which now seems quite far-fetched, given that it's been established since then that leakers to the press can be prosecuted, although the Supreme Court has never weighed in on that. But at the time, I mean, if you look at the Espionage Act, it purports to criminalize possession or dissemination of national defense information, not classified information. National defense information defined so broadly to include basically anything that could harm the diplomatic relations of the United States. So there has been this, I would say, sort of First Amendment gestalt, as Josh would say, around Espionage Act prosecutions of leakers to the press since then. The Supreme Court has not taken up whether this can be done. Actually, a CIA general counsel testified in the 1970s that if it was a felony to leak information to the press, then there's been an unprecedented crime wave in Washington going back decades, because there are 10,000s of those, tens of thousands every year. Now, we haven't seen until the Assange case, which we should do another webinar on, the Espionage Act being used against a publisher and not against a leaker. I would say, look, most of the concerns that have been raised about Espionage Act prosecutions are that it's essentially a strict liability statute. That once the fact is established that something is national defense information. And once you've given that to someone who's not authorized to receive it, or possessed it if you're not authorized to possess it, there's no other kind of public interest analysis that takes place. So in the context of leakers, it doesn't matter that the information that was given to the Washington Post and the New York Times led to Pulitzer Prizes for public interest journalism, led to changes in federal laws. None of that would be relevant or admissible in a trial under the Espionage Act. The only relevant and admissible fact would be you knew it was national defense information. You shared it with someone who was not authorized to receive it. Those concerns are not raised in the Mar-a-Lago case, right? There's no question here about publication. Trump was hoarding. There's no public interest in his having stacks of boxes in a bathroom at his golf club. That doesn't mean there are no constitutional issues that should be discussed in relation to this prosecution, simply because the Supreme Court has never really taken up the Espionage Act, right? So Trump could argue, his lawyers could argue, the term national defense information is unconstitutionally vague or overbroad. I would agree with those things, even though none of the other reasons why the ACLU has objected to Espionage Act prosecutions apply here at all. And Trump easily could have avoided this prosecution just by giving the documents back the first, second, 10th, or 20th time the government asked him nicely for them.
Josh, did you have a thought on that?
I'll raise a related point. This came up with the Letitia James litigation. Is this perhaps selective prosecution, which is almost a species of free speech? In other words, are the fact that all these prosecutions brought in perhaps such, not the strongest claims, perhaps evidence that this is political retaliation? And I know there's some thinking that the Biden administration was mad that Garland didn't charge Trump earlier and that they waited too long. I don't think you can actually state a claim for political retaliation, but perhaps all these cases fit into sort of a paradigm that this is done because of what Trump did. If he was any other government official who kept some records in his garage, would he have been indicted? Maybe, maybe not. Would they have gone after him for the inflation of property values? Maybe, maybe not. Would they have gone after him for paying off some hush money? Maybe, maybe not. But as all this sort of comes together, it does raise a specter that he's getting sued and indicted, especially heavily because of his political speech running for office again. If Trump had said, I am resigning from politics, I'll never run for office again, ever again, would we still have this? I mean, it's an unenforceable promise, of course, but would we have seen all these things if Trump just went off into private life and retired at Mar-a-Lago? And, I don't know. It's just a thought.
I mean, just one quick response. I mean, every leak prosecution under the Espionage Act is a selective prosecution, right? Because as I said, there are thousands and thousands of leaks of classified information that take place on an annual basis. I think it's pretty much of a stretch to say that here Trump got unfair treatment when, again, he had so many chances just to give the stuff back. I don't think any of us thinks that the case would have been brought if he had given the stuff back, right? Biden ended up with a special prosecutor without having been afforded the chance to give it back. I think they were right not to bring charges in that case as well. But I think, right, I mean, my read of this is that the DOJ did not want to bring this case and Trump forced them to. Through just stubborn intransigence. And usually with Trump, and you won't like this, Josh, but the best explanation is not the most nefarious or conspiratorial, but the stupidest.
Oh, I agree. I'm not gonna disagree
And
with
the
that.
stupidest one here is, it's mine, and I don't want to give it back to you. And he invited this case. I regret it insofar as it's now made a lot of people on my political allies all of a sudden happy about classification and secrecy, when in fact probably most of the things that are classified shouldn't be classified at all. But I think to say that Trump was here singled out is probably the opposite of the truth.
Does the ACLU think you might actually get some good case law out of this? Is that possible, or just because it's so tainted with Trump, it's hard to get any good case law out of it?
I mean, I think it's pretty unlikely.
Yeah, probably right.
So there are a couple of questions, and actually this might be a good one to wrap us up on because it's so general that it invites you to go in whichever direction you'd like to go. Do all the cases against Trump, I'm paraphrasing this, illustrate that the system is broken and that the law will be used as a weapon in politics going forward? When and how does this stop? Discuss.
Okay, I'll tackle that. You know, I think when you become a prominent person, and particularly a prominent politician, it would behoove you to be purer than the purest snow. And when you are a person who commits felonies right and left and in public and brags about being able to get away with it, you should expect to be under a microscope and to be prosecuted if prosecution is warranted. So I find this a disturbing question in the premises um, that it accepts. And going back to Josh's statement, you know, if you look at the case before Judge Marchand about election interference through falsification of business records, and the truth is, falsification of business records charges are brought all the time in New York, and most people reach a plea agreement. So we aren't as aware of them as we might be, but many of the people in that office say, this is our bread and butter. This is what we do all the time. Trump was not singled out. He just came to their attention. And when you come to their attention, they're going to prosecute. What disturbs me most about this question is the idea that future administrations will go after political enemies, which is what Trump has told us out loud he intends to do. And that's the end of the rule of law. So I don't think it's going on here. And the fact that we're even considering that it might go on in the future, that everybody would do it, is deeply disturbing and threatening in the same way that in the Supreme Court argument over the Colorado disqualification case, the Chief Justice accepted in one of his questions the premise that states dominated by Republicans would start barring Democrats from the ballot, even though there are no allegations that any Democrats in our lifetimes, as opposed to the Civil War era, were insurrectionists.
I'll just add. Oh, I'm sorry.
Go ahead.
I'll just add. And it's not First Amendment specific at all, but I worry about the same thing as Catherine. We saw it in the last Trump administration. As I mentioned, I'm representing Michael Cohen going forward. Ben and I had occasion to represent him together when in a First Amendment matter, when he was unceremoniously thrown into solitary confinement for having the audacity to tell his probation officer that he was writing a tell-all book about his former boss, Trump, and in violation of his First Amendment rights, they remanded him to prison. And so we brought a habeas petition and a TRO and successfully got him out. Obviously, he was a political opponent of the then president. I also represented Michael Avenatti. Now he had some issues, of course, but talk about selective prosecutions. He was running for president at the time, and I don't know why he was investigated, but he was, and he was eventually convicted, and I in a case that I didn't defend him on, but found by a jury to have been guilty. But enemies were prosecuted for sure, and friends, were commuted. And as Catherine said, we've been told, we've been promised that more, will come should he win a second term. So I do worry. I think the premise of the question is should be concerning. But that's just my own, that's my own take.
I'm going to end with one question here because I love it as a matter of First Amendment doctrine. This could be a Josh question, could be a Ben question, but just as we've talked about charging the speaker with knowledge of the propensities of the audience, could it cut in the former president's favor to argue that everyone knows my propensities, and my propensities are to speak in exaggeration, to speak in hyperbole, to engage in figurative rhetoric, so that when I say, come to Washington, it will be wild. When I say fight like hell or you won't have a country, everybody knows that to be figurative and hyperbolic because it's me. And that argument actually did get some traction in one of his Twitter libel cases, that look, anybody who follows the real Donald Trump Twitter account knows that when you tune into this channel, this is the kind of material that you're going to read. And so he did actually get the benefit of having sort of, been this over the top, entertaining, larger than life figure. Does that work in a criminal prosecution?
I'll start. There was a comment earlier about what do you do when everything Trump says is a lie. This is a person that almost everything that leaves his mouth is either hyperbolic, untrue, or close to the truth. Yeah, that's what he does, and that's part of the shtick, and that's why he got elected president, right? He would say things that are just so outrageous, and people sort of love it, and they vote for him. I know people in this call may not like it, but he might win again. It's entirely possible because of the way he approaches things. And when you have a person who engages, how do you figure out his intent, his mens rea? How do you figure out what his subjective intent is? And I think a lot of the media, no offense, spent 4 years trying to brain scan the guy, trying to figure out what's in his head. And I don't think you ever quite got it right. And then when courts try to figure out what was he intending with the speech, what did he intend would happen? I don't know that you can do that so effectively. What did he intend on January 6th? Maybe he knew at one point this, no, he gave this tweet, but he didn't tweet about this, and he told Mike Pence this, and he called Tommy Tuberville this. These are very hard questions, and proving criminal liability is tough. Maybe proving civil liability would be easier, but even then, I'm not there. I've been teaching now for about 12 years. I'm not as experienced as some professors, but I think every attempt to sort of cabin Trump has failed, and every attempt to try to apply the law to him just hasn't worked. And I just see the incitement case, the insurrection case, and so on, just further examples. He's perhaps a unicorn who our law just was not prepared to reconcile. So writing a book about him may just be, a task of mythical order.
Yeah, I think you could broaden this question a little bit to be not just about Trump's speech, but to be about political speech, which is hyperbolic, often dishonest. Joe Biden is going to take every single one of your guns away. Trump is a Russian stooge who's being directed by Putin, right? I mean, this is why I'm very skeptical of efforts to control political misinformation as well, just because politics is misinformation, and it always has been, and it's very hard to apply legal frameworks to the way that people speak publicly politically. And this is why when the ACLU supported Trump's impeachment, as we did, our board pointed to his private conversations, not his public political speech, because we're very nervous about, as Josh said before, sort of applying these standards to the rough and tumble of public political speech, even if you're not talking about Trump. Now, that does not apply to a phone call to the Secretary of State of Georgia saying, find me 11,000 votes. That does not apply to Trump telling the Attorney General, announce that you have found fraud so that I can activate the Republicans in Congress. Trump said plenty of things involving words to other people that have no First Amendment implications at all, and I think are properly viewed as part of an attempted conspiracy to overturn the election. But I do think we need to tread carefully, not make a lot of rules based on Trump without thinking about how they're going to apply more broadly to the rough and tumble of political speech.
Well, let's let that be the last word. Based on the audience reaction, we could keep this going forever, and I could certainly listen to it forever. But I want to thank our very busy panelists for taking time out to share their perspectives with us: Catherine Ross, Ben Wisner, Danya Perry, and Josh Blackman. And thanks to you watching this webinar. The section of Civil Rights and Social Justice provides these free webinars and other resources for legal professionals and advocates nationwide. We hope you find this useful in your work. And if you can, please consider joining and becoming active in the ABA. You can do that at americanbar.org/CRSJ. Best of luck in your work. Everybody stay safe, and thanks for listening.
Thank you.